Well, thank you for this opportunity, and I'm happy to be here, and especially to follow in the footsteps of my illustrious older brother. So I'm going to talk this afternoon about a case that preceded Brown versus Board of Education, much less well known, but still pretty interesting. And let's see, Mark showed me how to share my screen with a PowerPoint. So I will try to do that now. Okay, can everybody see that now? All right, good.
Yeah, it's coming through fine.
All right, great. Let me see if I can move that up there. All right, good. This is a portrait of Mr. Sweatt, and much of what you will see in this presentation or hear from me derives from several sources. Now, how do I get this thing to, okay, there we go. As you see, there are several different sources that I've read from and often plagiarized in this presentation. So I'll confess that much of what you'll hear is not my own, but from these sources, especially this that first book by Gary Laverne, Before Brown. That's a really well-written and engaging history of this whole drama as it played out in Texas. So I highly recommend that book especially. So who was Heman Sweatt? He was known as Bill. He was born into a family of educators. His father, the son of a slave, was one of the first graduates of what is now Prairie View A&M University in Texas. Mr. Sweatt graduated, that is, Heman graduated from high school in Houston and then from Wiley College as a biology major. Now, Wiley College is a historically Black college in deep East Texas. It's a four-year college. And besides Sweatt, its distinguished alumni include James Farmer Jr., the civil rights leader, Opal Lee, who is now 96 years old. She lives in Dallas, and she was a teacher. She's known as the mother of Juneteenth, and she, for years, and finally successfully lobbied for it to become a national holiday. And also Melvin B. Tolson, whose debate teams at Wiley College lost only one of 75 debates while he was there. His 1935 team won national attention by competing against USC's highly ranked debate team, and he was the inspiration for the Denzel Washington movie called The Great Debaters. Now, Mr. Sweatt became a teacher like his father and a substitute principal, but ultimately left education because of the poor pay and the poor facilities plaguing Texas schools for, quote, colored students. In 1937, he enrolled in the University of Michigan and did well in pre-med studies, but left after the first year due to fragile health. He then returned to Houston and took a job as a mail carrier and married his high school sweetheart. While in Houston, Mr. Sweatt became active in fighting racial discrimination, which led to his desire to study law. At the same time, the NAACP, led by Thurgood Marshall and local Black leaders in the former slave states, were in the midst of a prolonged strategy of legal action with limited success to overcome the separate but equal doctrine that the Supreme Court had established in 1896 with its Plessy versus Ferguson decision. The strategy had become focused on professional education in Texas for several reasons. First of all, the University of Texas had unparalleled wealth in the oil and gas reserves of the Permanent University Fund, so that it, of all the states, was best able to create a truly equal first-class institution for Blacks if the legislature had the political will to do so. Also, unlike the rest of Texas, the majority of the student body at UT was in favor of integration. So now all the NAACP needed was a reliable plaintiff for legal action against the state of Texas. Mr. Sweatt was the only volunteer, and he was a good one. So on February 26, 1946, Mr. Sweatt, with representatives from the NAACP, presented his application for admission to the University of Texas School of Law to Theophilus Schickel Painter, president of UT. Now, can you imagine if your mother named you Theophilus Schickel Painter, how you could possibly avoid your destiny of being in higher education? I don't know. The Texas Constitution at that time called for separate but equal schools for white and colored children, with impartial provisions made for both. Dr. Painter sought advice from the Texas Attorney General, who confirmed that Mr. Sweatt's application had to be denied under Texas law, even though he was fully qualified in every respect except for race. But the Attorney General did say that he would have to be admitted to UT if UT could not provide separate but equal facilities. And there's a photo of UT Law School around 1950, around the time of this story. Just a single building back then. So on May 16th, 1946, Sweatt filed suit in Travis County District Court. He was represented by William Durham, a prominent Black lawyer in Dallas, and by Thurgood Marshall of the NAACP Legal Defense Fund in New York. In response, Texas hastily tried to create a law school program at Prairie View A&M University, which was a historically Black school. The Travis County judge then denied Sweatt's petition on the finding that the education at Prairie View would be substantially equal to that offered at the University of Texas. Mr. Marshall argued that separate could never be equal. The Prairie View, quote, law school opened in early 1947, but no one applied for admission. While Sweatt appealed the Travis County decision, the state again created makeshift, quote, separate but equal law schools, including the derisively called basement school, but Sweatt refused to apply to those schools. He ultimately exhausted all appeals in the Texas state courts, and so then he appealed to the US Supreme Court on the grounds that he had been denied equal protection under the law as required by the 14th Amendment to the US Constitution. Now, there were two competing schools of thought on the issue among Blacks at that time, and the tension still lingers today. Should schools be integrated across the board, or should the state devote equal and very substantial resources to build and support historically Black schools? Marshall and the national NAACP leadership were in the integration camp, but many Black leaders in Texas were not. The state of Texas was suddenly, at long last, allocating substantial sums to historically Black institutions that had always been starved for funds. The leaders opposed to Sweatt's suit feared that if it succeeded and UT was integrated, the state would no longer have any motivation to divert funds to the Black schools. So the suit in the Supreme Court proceeded, and amicus briefs, that's friend of court briefs, were supporting the state of Texas, were filed by attorneys general of guess which states: Arkansas, Florida, Georgia, Kentucky, Louisiana, North Carolina, Oklahoma, South Carolina, Tennessee, and Virginia, those the former slave states. Representing the state of Texas were Price Daniel, the Attorney General, but Joe Greenhill, his assistant, carried the weight of the research and argument. So here's a photo of Thurgood Marshall on the right arriving at the US Supreme Court. Let's see, I'm going to back up. Well, never mind, that's fine. Mr. Greenhill raised the only serious defense to the Sweatt suit. He argued that framers of the 14th Amendment had never intended to integrate the races, which he supported by substantial documentation and logic. Ultimately, he led Marshall to concede that the history and intent of the amendment could support either side of the argument. Greenhill and Marshall respected each other and ultimately became friends. Greenhill later served a long and distinguished term as Chief Justice of the Texas Supreme Court. He insisted that his vigorous defense in the Sweatt case was required of him as a lawyer, though he did not support it personally. Texas law required segregation at the time. My client was Dr. Painter in the University of Texas, he said. Either I could do my best or I could quit, and I couldn't afford to quit. The Chief Justice of the US Supreme Court at that time was Vinson Jr. And so who was this man? Vinson was nominated by President Truman and succeeded Harlan Stone as Chief Justice. He served as such from June 1946 until his death from a heart attack in 1953 at age 63. He was uniquely qualified for the position because he had served in all three branches of the federal government: as a congressman, a federal judge, a high-level administrator for President Franklin Roosevelt, and Treasury Secretary under President Truman. Nevertheless, he is, quote, he is typically depicted as a bumbling, card-playing crony of Harry Truman, unsuited intellectually for the work of the court, and a weak leader with almost reactionary instincts in key civil liberty cases, and close quote. He was reviled by other members of the court, including Justice Felix Frankfurter, who told a clerk that Vinson's death was the first evidence he had ever had of the existence of God. Vinson was hardly a liberal. One legal scholar writes, quote, "No one would mistake Fred Vinson for a liberal. He almost always voted against free speech claims and the rights of criminal defendants. His plurality opinion upholding the prosecution of communists in Dennis versus United States, for example, is now viewed as an embarrassment or worse. As one historian put it, his decisions earned him a well-deserved reputation as a menace to civil liberties." Nevertheless, there's the Supreme Court decision in Sweatt versus Painter of 1950, authored with the opinion, a unanimous decision with the opinion authored by Chief Justice Vinson. Thurgood Marshall and William Durham again represented Sweatt in arguments before the court. The decision reversed the Texas courts, holding that the legal education offered to Sweatt was not substantially equal to that which he would receive at UT, and that the Equal Protection Clause of the 14th Amendment did indeed require him to be admitted to UT law. The court found that UT law was superior in all respects to the new allegedly separate but equal law schools hastily created in Texas, not only in terms of, quote, bricks and books, but also in terms of intangible opportunities offered to the students, as Marshall argued. The court noted that the law schools to which Texas would admit Mr. Sweatt excluded about 85% of the population of the state, including the other lawyers, jurors, judges, and other officials whom Sweatt would have to interact with as a lawyer. Moreover, UT law possessed to a far greater degree those qualities which are incapable of objective measurement, but which make for the greatness of a law school, including reputation of the faculty, experience of the administration, position and influence of the alumni, standing in the community, traditions, and prestige. So here's a letter from Thurgood Marshall congratulating Mr. Sweatt on the Supreme Court decision. And curiously, it says, let's see, I want very much to have you and Connie at the annual conference of the NAACP. And the only thing holding us up at the present time is that we just cannot find the money. If I do so, I'll wire or telephone you because we want to have you if there is any way possible. It would be a shot in the arm to our convention to have them see and talk with you. With all best wishes, sincerely, Thurgood Marshall, Special Counsel. Here you see Mr. Sweatt in line to matriculate at the law school with a few white frat rats next to him. It's kind of an amusing photo. But what was his legacy? 5 other Blacks enrolled with Sweatt at UT Law, along with scores of white men. Unfortunately, Mr. Sweatt lasted at the law school for only a year. The litigation had taken a toll on his health, as well as a failing marriage and the pressure of first-year classes. At that time, only 50%, rather a full 50% flunked out in the early 1950s. Later, he attended the School of Social Work at Atlanta University and earned a master's degree there, and then began a 23-year career with the Urban League. And he became responsible for organizing new chapters of the Urban League, which tripled during his tenure there. He remarried in 1963. His daughter is Heman Sweatt, MD, who is a dermatological pathologist. And he died in 1982. In Houston, the Texas State University for Negroes was renamed Texas Southern University. Informally, it is known as the house that Sweatt built, and its law school is appropriately named for his champion, Justice Thurgood Marshall. In Austin, UT Law School created a professorship and scholarship in Sweatt's name, and in 2018 placed many of the photos you've seen in this presentation prominently in the Sussman Godfrey atrium in the law school building. In 1987, the law school held the first Heman Sweatt Symposium on Civil Rights, which continues to this day. In 1987, UT also renamed the southeast side of campus the Heman Sweatt campus. And in 2005, the Travis County Courthouse, where Sweatt versus Painter was originally tried, was renamed the Heman Sweatt Courthouse. After Justice Vinson died in 1953, President Eisenhower appointed Earl Warren to succeed him as Chief Justice, and a year later, again with Thurgood Marshall leading the arguments, the Supreme Court handed down the far-reaching decision of Brown versus Board of Education, for which Sweatt versus Painter had paved the way. So in my mind, Heman Sweatt stands with Rosa Parks, James Meredith, and the countless other men and women who had the courage to fight at great personal cost for equal justice under the law. Let's see. So that's the end of my talk, and I'll be happy to try to answer any questions if anyone has any.
Stan?
Yes.
There were several other cases as well. There was one in Missouri that came down at the same time as Sweatt. You're saying that Sweatt had more influence than the other cases?
Not necessarily. Yeah, it may have. I don't know if the others, and I know there was one in Oklahoma as well. Yeah. I don't know their history in the Supreme Court. I do know that that Sweatt was a pretty pivotal decision in the Supreme Court. And of course, it's interesting to me because I'm a graduate of UT Law School.
Yes, okay. I was going to ask you if that was you, Toledo, or you, Texas? And
Texas.
So I guess. Texas.
Yes. Yeah. Yeah.
Stan, I've got a question
Sure.
about Chief Justice Vinson. Do we have any idea of how he came to his conclusion, or for that matter, any of the other justices? Because it was a 9-0 decision, right?
That's correct. And it's perplexing given Vinson's reactionary history that I recounted. It's kind of interesting that it was unanimous and that he authored the opinion.
Well, do we have any information as to how that decision was reached? Any of the mechanics and the processes about it?
Regrettably, I did not delve very deeply in that, so I really can't answer that question. But I'm sure it's out there somewhere. Anyone else?
Dan, you mentioned Texas Southern University, which I remember from our time in Houston. Pretty big outfit. And I'm trying to remember other historically Black public universities in Texas. Do you know of any others?
The only one I can think of offhand is Houston Tillotson College in Austin.
Okay.
There may be others. I don't know.
Okay. And I'm also wondering, do you know about any relationship between, who was the Supreme Court Justice Vinson? What was his first name?
Fred?
Fred, yeah. And Carl Vinson, who was a congressman and for a long time head of the Armed Forces Committee in the House, I believe.
Yeah, I don't know if they were related or not.
Okay, he's got an aircraft carrier named after him, if I'm not mistaken. So he was, Carl Vinson was from Georgia, so could have been a connection or just a coincidence. Okay, that's all I can think of for now, but
Maybe
very
he
nice.
was maybe he was a little bit more admirable a character than Chief Justice Vinson, with the shining exception of Sweatt versus Painter.
Right, right.
Stan,
Yes.
do you have some familiarity with racial studies literature, or how did this interest of this case come out other than being a lawyer?
Well, I guess it germinated when I was in law school, and mention was made of this case in my constitutional law class, and I really didn't know much about it at the time. But I've recently become, having spent a career and nearly entirely around people just like me, I've become interested in getting to know people who aren't like me. So become involved with the local unit of the NAACP and met some very fine people there. And so that's kind of what stimulated my interest in my new interest in this case. I haven't read widely in the racial justice literature, but I did read that book Before Brown that I referred to, and my friend from high school, Glenn Spidell, who's on this Zoom call, has recommended a couple of books to me, which I've read. So that's as far as I've gotten so far.
Well, I had a specific title and time in mind. Our book club is going to be reading Stamped from the Beginning by Zendi Ibrahim, or Ibrahim Zendi or something, here in the near future. I was just wondering if you had any familiarity with that one. It's been out since about 2016, 2018, something like that.
Yeah, I've read part of one of his books. I don't know that particular one, though. Glenn, you may be familiar with it.
Well, I've heard about it, but I haven't read it, so I can't comment on it.
And this is Mark Kinney. When I did my doctoral work in Nashville, I was asked to do a report on a fellow named Charles Hamilton Houston. Well, it turns out Charles Hamilton Houston was a lawyer. He was the first doctoral granted lawyer from Harvard who was Black. And he became a professor at Howard. And in the law curriculum, law schools often use moot courts to try cases.
Yes.
And Houston in the 20s, 30s, and 40s had his students work on how do you create equality for Blacks. And so all of these cases turn out to be a sequence of cases starting with the railroads and then ending with public education being equal. So Charles Hamilton Houston was Thurgood Marshall's professor.
Oh, really?
So it all ties together. It was just a totally amazing learning for me to see that what we now think of as integration started 35 years beforehand.
Mhm.
And the last little tidbit that I learned was in 54, Houston was pretty old. He was against bringing the case, Brown versus Board of Education. He still felt that it was impossible to win that case. But Marshall went ahead and did it. Pretty cool.
So was he in favor of integration, or was he in the camp of those reluctant for integration because of like I described in my talk about, let's preserve Black culture on its own. And now all of a sudden the state is devoting substantial funds to it. So let's keep that going.
He was definitely in favor of integration.
Okay.
Yeah.
Stan, I have another question.
Okay.
Is the NAACP or any other organization that's there for advancement of justice and rights for Blacks still organizing test cases of laws and assisting plaintiffs, selecting and assisting plaintiffs with the explicit idea of seeing whether a high court opinions can overrule existing laws. Now, I think that goes all the way back to Plessy and Ferguson. I believe Mr. Plessy was encouraged, and there was part of an organized effort to test separate but equal. So is that still going on?
I suspect it is, but perhaps to a much more limited degree because most of that ground has already been won. At least from a legal standpoint, maybe not from a practical standpoint, but from a legal standpoint. And it requires a true champion like Thurgood Marshall to really make headway in those types of cases. And there have been, lots of people since him who've done very well in that regard, but I'm not aware of, I don't know of any particular cases at this point that are ongoing. I expect there are, but I just don't know about them.
Okay.
What I do know is that the Legal Defense Fund is still operating within the NAACP.
Yes.
And they're very active in representing candidates that are having trouble with integration and those kinds of issues. But I don't have evidence that it's based in trying to change the law changed the precedent as Brown versus Board of Education or Sweatt and versus Painter were.
That makes sense.
Stan, I've got a question about this case. This question sort of spins off of an earlier question that was asked about this case being utilized at the University of Texas, and you mentioned you studied it in con law class. And my question is, do you know if it's part of the standard repertoire in many law schools today in terms of civil rights cases, specifically regarding separate but equal?
I think that it probably is, although it probably, as in my con law course, it probably receives only passing mention. You know, the big focus is on Brown versus Board of Education and similar major, well-known cases like that. There's only so much you can cover in a semester when you're trying to cover all of constitutional law. Well, thank you very much, everyone. I enjoyed giving this talk and hope it was beneficial to you.
Yes, it was. Thank you.
Very good. Very enlightening. Thank you.